No one.
Wait, please, Your Lordship.
Now we've got the lineup. Mr. Prashant Bhushan has said 4 hours. Mr. Sibal, 4 hours.
Because, my Lord, I have to lay out the factual details also. So that's why I will take it.
Take 4 hours.
Mr. Bhushan, you will also 4 hours will be too long because we have to cut short the.
Because the laying out of factual details itself will take over an hour. Otherwise, my argument should not take more than 2.5 hours
You
max.
can cut it down to about 2 hours so that we'll.
I'll try. I'll try.
Within 2 hours, just then you can
try.
supplement it.
I'll try. First of all, Lord, I wish to say that this is a case which goes to the very root of our democracy.
Yes.
And I'm glad, my Lord, that the court has finally fixed it for hearing and constituted a constitutional bench, given the importance of the case. Lord, I have been in the PIL space for many years, but I have never seen this kind of public interest involved in any PIL that I have ever done. I mean, the amount of interest that this has aroused is absolutely astounding. Lord, there are, I'll just show your Lordship what the electoral bond scheme is. By this petition, my Lord, we have this, I am appearing for ADR, and we have filed written submissions which are in volume 1 and start at page 1. We have, in our written submissions, my Lord, mentioned that we are challenging in our petition also, we are challenging the amendments brought in FCRA by the Finance Act of 2016. So first, my Lord, in 2016, and the issue about whether they could have been brought through the Finance Act or not, I am not pressing right now, though we have taken that issue in our petition. But I am not pressing it for the reason that I want this case to be decided before the elections. I don't want, because I know that your Lordship has issued the finance bill issue to a 7-judge bench, and I don't want this to await that. So I'm restricting myself to the other grounds of challenge. So first, my Lord, we have challenged the amendments brought to the Foreign Contribution Regulation Act of 26 by the Finance Act of 2016. And in essence, my Lord, those amendments were that prior to that amendment, we have actually in our written submissions, my Lord, we have given a chart of the amendments. And the amendment regarding the FCRA is at page 10.
I'm sorry, generally, my lord, we don't interrupt. But by a judicial order, my lords have been pleased to separate and detag the issue regarding FCRA. There is a judicial order passed by your lordships.
No, my Lord,
Lord, he has started with that, my lord. Therefore, it's.
I'm
seems
just
he has
pointing
missed
out
that
what
order.
we have challenged in this petition. If your Lordship just sees, in this petition, which is before your Lordship today, we have challenged the amendments made to the FCRA also by way of the Finance Bill of 2016. And the amendment was that prior to that, the foreign contributions were prohibited to political parties and candidates and public servants. By this amendment, they have effectively permitted foreign contributions by saying that any contribution made by way of donation through a subsidiary of a foreign company which is registered in India will not be treated as a foreign source. So by this amendment, effectively, you have allowed, so for example, my lord, suppose, I'm just giving an example, a foreign company wanted to donate money to a political party. It was earlier totally prohibited from doing so, and in fact, one of these cases went to the, in fact, this amendment was in a way brought in order to overcome a judgment of the Delhi High Court, by which the Delhi High Court held that both the BJP and the Congress party had received foreign contributions through a subsidiary of a foreign company. At that time, it was Sterlite, which was a subsidiary of Vedant Resources, which was a UK-based company. And they said that therefore appropriate action should be taken against these political parties. To overcome that, my lord, a retrospective amendment was brought through the Finance Act into FCRA by saying that if the donation is made by a subsidiary of a foreign company, in that case also that was a subsidiary, Sterlite was a subsidiary of Vedant Resources UK, then that will not be treated to be a foreign source. So this is the amendment which has been brought, and we have mentioned this, my lord, at page 10 of our written
That
submission.
has strictly speaking no relevance to the challenge on the electoral bond scheme.
True, true. But I am only saying that.
Which is perhaps why the solicitor mentioned that
Yes, but
that has been
my lord,
detagged.
that
That issue was
electoral
detagged.
bond scheme,
Segregation of 3 cases.
31st of January 23 order, your lordships, my lord, were pleased to segregate.
in this, my lord, the original amendment of 20, brought in by the Finance Bill of 2016 to the FCRA has been
All
challenged.
right, what is the next challenge in your petition? We'll just at least have a broad
Yes, yes.
purview and then we can go on to
Yes,
the.
yes. So the challenges are all in this chart, if your lordship just sees.
Page 10.
Page 7, volume 1, page 7, in our written submissions. Yes. So first is the amendment made to the Representation of People Act. Earlier, my lord, the Act said 29C. On the left side is the original and the right side is the amendment. Amended. Earlier, my lord, the Act said, RP Act said, the treasurer of a political party or any other person authorized by the political party in this behalf shall in each financial year prepare a report in respect of the following, namely, A, the contributions in excess of 20,000 rupees received by such political party from any person in that financial year. B, the contribution in excess of 20,000 rupees received by such political party from companies other than government
Mr.
companies
Bhushan,
in that
you are
financial
at page 10.
Pardon, Lord?
You are at page 10.
Page 10. At the bottom, 7, sorry.
7.
I'm sorry, page 7. Page 10 was that FCRA I had taken. Page 7.
Yes.
So left side is the original provision. And then, my lord, 4 said, where the treasurer on the left side, original, where the treasurer of any political party or any other person authorized by the political party in this behalf fails to submit a report under subsection 3, then notwithstanding anything contained in the Income Tax Act, such political party shall not be entitled to any tax relief under that act, because contributions to political parties are exempted at both ends. That is, it's exempted at the end of the party which receives the donations from tax, and it is also exempted at the end of the donor. That is, the donor can claim an exemption by way of the donations that they have given to a political party. Now, your lordship will see the amendment. I have highlighted the relevant part. Provided on the right side, provided that nothing in this subsection shall apply to contributions received by way of electoral bonds. So therefore, the reporting requirement as to who has donated to you in excess of 20,000, which was earlier there, has been removed for donations received through electoral bonds. This is the first amendment to the Representation of People Act. Then they amended simultaneously the Companies Act. All these amendments were brought in through the Finance Bill of 2017. Finance Act of 2017. Now the Companies Act 182 originally prescribed, notwithstanding anything contained in any other provision, a company other than a government company and a company which has been in existence for less than 3 financial years may contribute any amount directly or indirectly to any political party, provided that the amount referred to in subsection 1, as the case may be, the aggregate of the amounts that may be so contributed by the company in any financial year shall not exceed, this is important, shall not exceed 7.5% of its average net profits during 3 immediately preceding financial years. So there was a limit, there was a cap of 7.5% of last 3 years average profits on the amount of corporate donations that any company could give to a political party. That proviso has been omitted by this amendment. So this is another thing other than electoral bond. Simultaneously, my lord, a slew of changes were made. One was, and all these have been challenged in our petition. Then, my lord, 182.3. Every company shall disclose in its annual profit and loss account any amount or amounts contributed by it to any political party during the financial year to which the account relates, giving particulars of the total amount contributed and the name of the party to which such amount has been contributed. So earlier the requirement was that you have to disclose which political party you have donated to. Now, my lord, in the amendment, they say, provided every company shall disclose in its profit and loss account the total amount contributed to it under this section during the financial year to which the account relates, provided that a company may make contribution through any instrument issued pursuant to the scheme notified under the Act for the time being in force for contribution to political parties. So therefore, now, after the amendment, all that they have to disclose is the total amount, not the donee political party. They don't have to disclose which is the political party to whom they have given these electoral bonds. Earlier, there was a requirement to disclose that. Then, Income Tax Act. This has also been amended by this. I read it. Then, Lord, Income Tax Act. So earlier 13A said, any income of a political party which is chargeable under the head income from house property, income from other sources, or income by way of voluntary contributions received by a political party from any person shall not be included in the total income of the previous year of such political party. And then proviso said, provided that
Yes.
such political party keeps and maintains such books of account or other documents as would enable the assessing officer to properly deduce its income therefrom. B, in respect of each such voluntary contribution in excess of 10,000 rupees, such political party keeps and maintains a record of such contributions and names and addresses of the person who have made the contribution. So therefore, there was a requirement in the Income Tax Act that every political party should maintain accounts of where they have received the donations from, who has given them the donations. Now, by the amendment, it says, proviso says, provided that B, in respect of each such voluntary contribution, other than contribution by way of electoral bond, in excess of 10,000, such party keeps and maintains record of such contribution and the name, address, and address of the person who has made such contribution. So again, the requirement of keeping a record is omitted for electoral bonds. And then, my lord, D, no donation exceeding 2,000 rupees is received by such political party otherwise than by account pay check drawn on a bank or an account pay draft or use of electronic clearing system through a bank account or through electoral bond. So everywhere, my lord, electoral bonds have been not only introduced, they have been exempt from disclosure under the Companies Act, under the Income Tax Act, under the Representation of Peoples Act, etc. And then, my lord, at page 10, this is of course the Reserve Bank. Reserve Bank Act only says that this will be a new financial instrument which has been introduced. Issue of demand bills and notes, and here it says the amendment at 3 says, notwithstanding anything contained in the section, the central bank may authorize any scheduled bank to issue electoral bonds. At the bottom of page 10 towards. And then, as I said, my lord, in the FCRA, which has also been challenged in this petition, now prior to the amendment of 2016, this is important for the reason that when I make my argument as to what this slew of amendments has done, it has, on the one hand, my lord, introduced an opaque instrument by which nobody can come to know other than the government. It is only the government who may be able to come to know as to who has contributed to whom, because under the scheme, State Bank has to issue the electoral bond. So State Bank has a record of who has purchased which electoral bond. Now, of course, the bonds are bearer bonds. They are freely transferable. So suppose I purchase the bond, State Bank will know that yes, I have purchased this bond. But I can hand it over to somebody else, and that somebody else can give it to a political party. The political party also may not come to know who has donated. Political party, it's open for a political party to say that, well, we opened our office in the morning and we saw these 100 crores of electoral bonds lying under our door. We deposited these electoral bonds. We don't know who has given them, because these are bearer bonds. So therefore, all that the political party will disclose in their accounts would be that out of the total contributions that they have received, donations that they have received 500 crores by way of electoral bonds. That they have received total 700 crores, out of which 500 crores are from electoral bonds. That's all. But that match of who purchased this electoral bond and which party encashed this particular electoral bond, that match, if at all, it can only be done by the State Bank, which is a Government of India institution. Of course, State Bank is also effectively prohibited from disclosing it. But the scheme says that if a law enforcement agency needs to know this, get this information, it may ask the State Bank to disclose this. So if at all, only a law enforcement agency, which are all essentially controlled by the government, or the government itself, because it controls the State Bank, can come to know only this much, that this particular bond was purchased by this company and this was encashed by this party. But nobody else can come to know this information under the scheme of electoral bonds. Nobody else. They are not even the Election Commission, because the only account that is submitted to the Election Commission by the political parties is that we receive so much by way of electoral bonds. They are not obliged to disclose who gave them. In fact, they may even say, we don't know who gave it. We opened our office, it was lying under the door, we encashed it. So therefore, they may even turn around and say that. In fact, there is an interim order of this court in this very case, by which this court said that all political parties should disclose the donors of these electoral bonds to the Election Commission pending the hearing of this case. There is an interim order to that effect. But when that information is finally seen, I dare say, my lord, that some of these political parties would have said, we don't know. We don't know.
on the SBI issuing bonds to persons who are not residents in India?
Yes, the requirement is that they have to give a KYC, whoever purchases electoral bonds. So the identity of the person who purchases the electoral bonds will be known to the State Bank of India. But because they have now opened the route by making this amendment that the limit of 7.5% of the annual profits has been totally removed. So even if you are a loss-making company, or even if you are a company which does no business, just a pure shell company, let's say, my lord, your lordship is aware that in that Adani SEBI matter, they are saying, SEBI is saying, we don't know whether these companies who have invested in the Adani companies from Mauritius and from these tax havens, whether they are in fact owned by Adani or not, or whether they are related to Adani or not. Now it is open to any of these companies to set up a subsidiary in India and donate to any political party of their choice any amount, even if it's a pure shell company, which means no business, no profits, just an amount is received from its parent company, which is registered in a tax haven, and that amount is given to a political party. So one of my arguments, my lord, I have three main arguments which I am going to argue before your lordship against these electoral bonds. The first is that it defeats the people's right to be informed about the sources of funding of political parties, which in my respectful submission and in the light of several judgments of this court is a fundamental right of citizens under Article 19(1)(a). That's the first argument. Because right to information has been held to be a fundamental right under Article 19(1)(a). In fact, in that ADR judgment and then in the follow-up PUCL judgment, this court said that every citizen has a fundamental right to know about the assets and liabilities of every candidate, about the criminal antecedents. And when that was sought to be overcome by means of an amendment, that amendment was struck down on this precise ground.
Right. That's the first submission. What is the second?
That's the first. Second is that this opaque instrument, anonymous instrument, in fact promotes corruption in the country because there is good reason to believe, and I'll show my lord why, that these bonds are being given by way of kickbacks to parties in power. Almost all the bonds have been received only by parties in power. More than 50% have been received only by the ruling party at the center. And the rest have been received only by the ruling party in the states. Virtually nothing, not even 1%, has been received by opposition parties which are not ruling in the center or at the states. And virtually all the bonds have been purchased by corporates, by companies, because they are almost all of denomination of 1 crore and above. 95% are in the denomination of 1 crore. 1 crore. Therefore, my lord, and you have simultaneously amended you have removed the cap on corporate donations and amended FCRA.
All right. There's a second submission.
That's the second submission.
The
The third submission is, my lord, that it disturbs and indeed destroys democracy in this country because it does not allow a level playing field between political parties which are ruling versus political parties which are in opposition, or between political parties and independent candidates. It will have, in fact, my lord, just to give your lordship a small figure, in the last 5 years, of which since the electoral bonds were introduced, 2017 they were introduced, 17, 18 to 21, 22, 5 years? 5 years. The contribution to political parties by way of electoral bonds has far exceeded any other method of contributing to political parties. Not only that, the amounts are so large. Just take one party, the ruling party at the center. The contributions by way of electoral bonds to just this one party ruling at the center is more than 5,000 crores in just a period of less than 5 years. Now just look at that figure. The limit for spending on each candidate fixed by the legislature is less than 1 crore per Lok Sabha constituency, less than 1 crore. If you set up candidates in all the constituencies in the country, the total amount that can be spent by the candidates of any political party is less than 500 crores in a Lok Sabha election. In just these 5 years, one party which has received the bulk of the political funding by way of electoral bonds is getting more than 10 times the maximum permissible expenditure on elections by its candidates. More than 10 times. So just see, my lord, what this is doing to our democracy.
What is the maximum permissible limit for a candidate?
70 lakhs or so.
Parliamentary constituency.
70 lakhs.
Of course, my lord, this limit is not adhered to. We all know that, because candidates are spending 10 times, sometimes 100 times the amount in cash. Now, Election Commission says, though it's a corrupt practice, spending more than the limit is a corrupt practice, but Election Commission says, look, we can't catch them. Everybody knows that many candidates are spending many times by cash. One of the arguments in this for introducing electoral bonds was, the stated argument of the government was that, well, this goes through the bank. These electoral bonds can only be purchased through bank transactions by check draft or direct transfer. Therefore, it will reduce cash. That was their argument. But I think very simple. If you wanted to curb the role of cash in elections, all that you had to do was to pass a simple amendment saying no political party or candidate shall be allowed to spend or take any money through non-banking channels. Everything will have to go through banking channels. And if you do that, it will be a corrupt practice. Suppose such an amendment, when this note ban was brought to Lord, one of the objectives given, stated objectives of the government was that we want to make a cashless economy, because we want the role of cash to be reduced. Now, I can understand that ordinary person on the street can't be made cashless. He can't be expected to do all his transactions through check and banking channels, but political parties and candidates contesting elections, they could have been made cashless by this simple law saying that you have to, or if you are a candidate or if you are a political party, all your transactions have to be through banking channels. But that was not done.
All right, now, Mr. Bhushan, let's do this. Let's look at the scheme of the electoral bond.
Yes.
And then you can make your submission. Because
Yes.
we've seen the amendments which have been made.
I fought the election in 2014 and it was 70. Today, whether it's 95 or 75 for a parliamentary constituency.
How much? 95?
95 or 75, depending on the state. For example, Andhra Pradesh is 95, Arunachal is 75. And for state elections, it's 40 and 28.
It's
Prashant
out of, when you,
is 20.
do you have to maintain a separate account for all this? Open it?
Yes.
Every candidate has.
Every day, Malaj, we have to submit what we have spent every day.
Every candidate as well as every political party.
Yeah, they could.
Yes.
And
So
this
the
is
election-
reflected in the conduct of election rules, rule 90 gives this table, so that your lordships have it.
Just one last thing I wanted to show, the amendment in the FCRA, just for your lordship's clarity, that is at page 10, at the bottom of page 10. So earlier, my lord, foreign source included. 3 is a foreign company. And by this amendment at page 11, my lord, it said, provided, proviso at the bottom of that highlighted part, provided that where the nominal value of the share capital is within the limit specified under FEMA or rules or regulations made thereunder, then notwithstanding the nominal value of the share capital of a company being more than 1/2 of such value at the time of making the contribution, such company shall not be a foreign source. So if you are a subsidiary of a foreign company and you own even 100% of the shares of your subsidiary, provided it is within FEMA, it's not regarded as a foreign source. So even the subsidiary of a foreign company can now donate to political parties. That's why this is important. Actually, this was a whole slew of amendments brought almost together, 2016 and 2017. It's a bouquet. And by this bouquet, because that limit has also been removed, therefore, my lord, it's allowing shell companies also to donate. Earlier, shell companies could not have because there was a limit, 7.5%. Now, shell companies can also donate. You can set up, you have a foreign company which is in a tax haven. You set up a subsidiary here as a shell company, and through that, you buy electoral bonds and donate to a political party. And nobody comes to know that a foreign company is now financing this political party, or these companies are financing this particular political party, etc. Now, my lord, we have mentioned the salient features of the scheme here at the bottom of page 11, but I can show your lordship the scheme itself, which is in volume 4, page 118. Volume 4, page 118. But I have mentioned all the salient features even in the written submissions. Electoral bond means a bond. I am now reading the scheme. Page 118. Electoral bond means a bond issued in the nature of a promissory note, which shall be a bearer banking instrument and shall not carry the name of the buyer or the payee. It's like cash. Only difference is that it's a cash which can go up to 1 crore. It's a note which can go up to 1 crore, from 10,000 to 1 crore. Today, my lord, we have only notes of 500 rupees or less. Even 2,000 rupees has now been demonetized. But here it's 10,000 to 1 crore. 1,000 to 1,000 to 1 crore. 1,000 to 1 crore. Now, eligibility for purchase of 3. Eligibility for purchase and encashment of electoral bond. The bond under the scheme may be purchased by a person who is a citizen of India or incorporated or established in India. So it can be an individual or a company. A person being an individual can buy bonds either singly or jointly with other individuals. 3. Only political parties registered under 29A of the RP Act and have secured not less than 1% of the votes polled in the last general election to the House of People or the Legislative Assembly, as the case may be, shall be eligible to receive the bond. So this itself restricts it to only those parties, not all parties are eligible, those who have received at least 1% vote, either in the Lok Sabha or in the State Assembly. The bond shall be encashed by an eligible political party only through a bank account with an authorized bank. Denomination, the bond should be issued in the denomination, shall be issued in the denomination of 1,000 to 1 crore. Validity of the bond shall be valid for 15 days from date of issue and no payment shall be made to any payee political party if the bond is deposited after the expiry of the validity period. I might just point out, my lord, on occasions they have increased the validity period under this also. And then 4, the information furnished by the buyer shall be treated as confidential by the authorized bank and shall not be disclosed to any authority for any purposes except when demanded by a competent court or upon registration of a criminal case by any law enforcement agency. So, acha. It's all right. It's not so important. So therefore, this has to be treated as confidential by the state bank, this information about who has purchased the bonds, and it can be disclosed only to a law enforcement agency which is pursuing some investigation. But I am saying, my lord, that if at all anybody, at one point the government had said, and this court by one interim order has also recorded, that there is at least some transparency in this because the company which purchases it has to disclose, because the political party which receives it has to disclose not the identity but has to disclose how much bonds they have to disclose, how much they have purchased, the company has to disclose, the party has to disclose how much they have received total. They say you can do some mix and match and find out who has donated. Now, mix and match can't be done by ordinary citizens for several reasons. Ordinary
Who
citizens.
said that we can do mix and match?
The court in one order has recorded this. This is on the basis of the submission of the government. On the basis of the government submission, the court in one interim order has recorded this. I'll show. Now, mix and match can't be done by ordinary citizens. In fact, my lord, even if I wanted to find out which companies have purchased electoral bonds, there are 23 lakh registered companies in India, 23 lakh. I would have to scan of course, every company is obliged to file the returns of their income and expenditure in the Ministry of Corporate Affairs website. And by paying some fee, I as a citizen can also access that website of that company to see what is the income and expenditure of that company. So theoretically, it is possible for me to find out which company has purchased electoral bonds worth how much, purchased and given. But I won't know who have they given it to. All that I will know is total amount purchased by them. Now, citizen can't be expected to go through. Of course, we have found out about some companies which I'll be coming to. I'll give those examples, which have purchased electoral bonds because that can be seen from their disclosure to the corporate affairs. But I can't be expected to find out from 23 lakh registered companies who has purchased how much electoral bonds. But government can. State Bank of India knows. And because State Bank is owned by the government, therefore, theoretically, my lord, they can. if they exert sufficient pressure on the state bank, they can find out who has purchased this particular electoral bond. Because state bank has that information, though they are prohibited by law from disclosing it to anybody by the scheme. But they have that information. And they also have the information as to which political party has encashed which electoral bond. So state bank is the only authority which can do that mix and match. Which can do that mix and match. Citizens can't do it. And I am saying, my lord, that this defeats the citizens' right to know about who is funding these political parties. In fact, my lord, in a recent judgment, the Central Information Commission has ruled that these 6 national parties are public authorities under the Right to Information Act. Now, unfortunately, despite that judgment, most of these political parties are not obeying that. They are not appointing information officers, which they are obliged under the RTI Act, so that people can ask them questions. We have in fact filed a petition in this court on the basis of that CIC judgment, as well as the RTI Act, as well as the fundamental right of people to know, etc., which is pending, which has been separated by this court. But I am pointing out that here you have completely made mincemeat of people's right to be informed about funding of political parties by introducing an instrument which today forms the bulk of donations to political parties. They are the bulk of donations to political parties today, this instrument. Then, my lord, 12 of the scheme says, the bond can be encashed only by an eligible political party by depositing the same in their designated bank account. So these are the broad salient features of the scheme. That, however, these are bearer bonds, and as I said, my lord, even the person who has purchased it may just hand it over to another XYZ, and that XYZ may give it to the political party, and therefore the political party can also turn around and say, I don't know who gave me this electoral bond. Somebody came and gave it to me. I don't know. In fact, I have been the recipient myself of, there was this register of the CBI director. Somebody came to my residence at night and gave me 2 volumes of the residence register, original register of that CBI director. And actually, I didn't know who is that person. There were these 2 people who came and gave it to me. But when I looked at the register, I could make out that this has to be original. Nobody can fabricate these kind of details. The time, date, car number, persons, and so on, visiting the CBI director. And on the basis of that, this court then ordered an SIT to be constituted because he was being visited by several people who were being investigated by the CBI at that point of time. But I'm saying that sometimes I get information from people whom I don't know. But I know that this is authentic information because I can make out by looking at it that this has to be authentic. In that case, my lord, initially the court asked me to disclose who gave you the register. So this was a petition by CPIL. We held a meeting of CPIL and we decided that, of course, I didn't even know, but we decided to take a principled stand that whistleblower has given it and we can't disclose the name of the whistleblower. So I'm saying that a political party can easily turn around and say, we don't know who has given it. Somebody left it. Because this is a bearer bond. Now, my lord, coming back to the submissions. So I have stated the salient features. In this, there are 1 or 2 other things also. That the window, if your lordship turns to page 12 of my written submissions, the window of sale of electoral bonds
That's right. Can you come to the 3 points to your?
Yes, yes, I'm coming,
You
Lord.
have seen the scheme now.
Yeah,
Let's go
right.
straight to your submission.
Right, right. And now, my lord, coming to my submissions, they start at page, first, your lordship may see the previous orders of this case, which I have quoted at page 15. Pa- गवर्नमेंट का जस्टिफिकेशन लिखा देता है ठीक है क्या चीज ठीक है चल I just wanted to read the justification given by the government for these electoral bonds. At page 14 of my written submissions, I have quoted the relevant part. Para 15 of my written submissions. On 7/1/18.
Volume 1.
Volume 1, page 14 of my submissions. On 7th January 2018, 5 days after the introduction of the scheme, the PIB published an article written by the then Finance Minister on the necessity for introducing electoral bonds. The stand of the government was that expenditures of all political parties runs into thousands of crores. However, there has not been a transparent funding mechanism of the political system. The said PIB released quotes from the then Finance Minister's article. Quote, the conventional system of political funding is to rely on donations. These donations, big or small, come from a range of sources from political workers, sympathizers, small business people, and even large industrialists. The conventional practice of funding political system was to take donations in cash and undertake these expenditures in cash. Sources are anonymous or pseudonymous. The quantum of money was never disclosed. The present system ensures unclean money coming from unidentifiable sources. It is wholly non-transparent system. Most political groups seem fairly satisfied with the present arrangement and would not mind the status quo to continue. The effort, therefore, is to run down any alternative system which is devised to cleanse the political funding mechanism. It further said that most donors are reluctant to disclose the details of quantums of donations given to a political party. A major step was taken by Shri Atal Bihari Vajpayee. The Income Tax Act was amended to include a provision that donations made to parties would be treated as expenditure and would thus give a tax advantage to the donor. If the political party disclosed its donations in a prescribed manner, it would also not be liable to pay tax. The political party was expected to file its returns both with the income tax authorities and the election commission. It was hoped that the donors would increasingly start donating money by check. Some donors did start following this practice, but most of them were reluctant to disclose the details of quantum of donation given to a political party. This was because they feared consequences visiting them from political opponents. The law was further amended through UPA government to provide for pass-through electoral trust so that donors would park their money with the electoral trust, which in turn would distribute them to various political parties. Both these reforms taken together resulted in only a small fraction of the donations coming in the form of checks. And therefore they say we have now introduced these electoral bonds because, in fact, my lord, this is at the whole
What was the electoral trust?
electoral trust is now is a kind of
2013, that was 2013.
semi-anonymous instrument. This is what it is. So any company can form or set up what is called an electoral trust, so long as it is recognized by the income tax department. In this electoral trust, any company can donate. So let's say that any company A has set up an electoral trust. Companies B, C, D, E, etc., they all donate to that trust. And that trust then donates to different political parties. So it's a kind of semi-anonymous system. Semi-anonymous meaning, of course, in income tax, they have to disclose who are the companies who have donated to this trust. They are also expected to disclose which are the political parties to which the trust has donated. But which company has donated to which political party is not known. Sometimes they may say, well, we didn't say, but in fact, my lord, what would be happening, I expect, would be every company donating to an electoral trust would say, look, I am giving this trust 50 crores and we want this 50 crores to be donated to A and B political parties. Normally, that's what is likely to have been happening, likely to be happening through these electoral trusts. So this is also a kind of semi-anonymous way, not totally anonymous, because you can come to know which are the companies who have donated to this electoral trust, and you can also come to know which are the political parties that this electoral trust has donated how much money to. So in that sense, there is more information than you have by way of electoral bond. But now, the justification, so the government said that we want to reduce cash. Earlier, people were donating through cash, and therefore, they also said that we have reduced this disclosure requirement from anything above 20,000 rupees to anything above 2,000 rupees. Though, my lord, that amendment was only made in the Income Tax Act, not followed through in the Representation of People Act. But let's assume that it would have been made even in the Representation of People Act. That means the law earlier was that you have to disclose any donations above 20,000 rupees. The political party has to disclose to the income tax as well as to the Election Commission. Anything received above 20,000 rupees, that has been brought down to 2,000. How will that reduce cash? Because earlier the party said that, look, we have received X crores by way of donations, small donations below 20,000. Now they will say, we have received the same X crores by way of small donations below 2,000. That's not going to make any difference, because all that the party has to say is, we put out a sheet, we held a rally, we put out a chadar, and people put money in that. Somebody put 500 rupees, somebody put 200 rupees, somebody put 100 rupees, etc. And we have collected X number of crores from small donations in this manner. So therefore, that is not going to make any difference. If you had said, on the contrary, that every political party will only take money through banking channels and cash receipts are prohibited, they are a corrupt practice, or that the party shall be deregistered if it starts taking money, or the candidate will be disqualified if he takes money by cash, then yes, you could have done something to stop this menace of cash, etc. This has not stopped the menace of cash. Today, my lord, candidates are still spending many times the amount by way of cash, and they are not being caught. They are not being caught, unfortunately.
Right, now let's get into the submissions.
Yes,
You
ma'am.
can just show us.
Now,
what you
just
want.
one more thing.
Section 13B of the Income Tax Act, read section 2, people.
Now, my lord, coming to the previous orders of this court in this matter.
Section 13B read with?
13B,
Read with?
in the Income Tax Act.
Oh, read with you see.
AAA.
It is not say about the
वो दिखा दो।
especially
दिखा दो।
the definition of electoral trust is section 1 within
Hmm?
that.
Section 2.
22.
Now, my lord, one of the justifications given by the government for electoral bonds was that donors are reluctant to donate openly to political parties because of fear of whatever. Now, so we asked this question under RTI. So that response, RTI response, my lord, is in volume 4, page 536. Volume 4, page 536. They say, 2. SO and CPIO Budget Division gave their inputs in respect of Electoral Bond Scheme 2018 pertaining to pre-budget division subsequent to 7/6/2017, the date of assigning the job to the budget division as follows. As regards point A and B, no representation or petition or communication has been received from the donors regarding the need for maintaining confidentiality of the identity while making donations to political parties.
This
So
may
clear-
not, this.
Yeah,
right,
this may not be really very relevant,
This
actually.
may not be
No, I
relevant
know
because it's
that.
already, they already know it's confidentiality is in a way maintained under the.
No, so that justification given by the, I'm only showing this to show that one of the justifications given by the government for introducing the electoral bond scheme was They said that, look, we are introducing this anonymous instrument of funding political parties because donors are reluctant to disclose who they are funding to. So we asked this question, was any representation received from any donor whatsoever that, look,
No, but you don't have to have a representation from a donor to perceive that reluctance. I mean, we're just trying to analyze, RTI response really will not carry your submission any further.
no, I'm
But-
saying that government should have some
There's an
basis.
assumption that, look, if you
That-
disclose the name of the donor, there'll be other political parties who will know that you have contributed to this political party, and therefore they might be subject to, suppose a donor is carrying on business in the state. If the name of the donor is made available to all the political parties, the rival political parties will say, well, or especially if you are making a contribution to a
only-
party which is not in power.
Only fear would be from the party.
That's the logic. Whether it's valid or not is what we have to
Correct,
decide.
correct. Now, your lordship may come back to my written submission. I just want to
Prashant
show,
Bhushan, you're on, the first argument was right to information under 19.
I'm coming to that. I just wanted to lay out the few other
Now
factual
let's
details.
look at the material what
No,
you
no,
are supporting.
interim orders, my lord, two things.
Yes,
Interim
let's see the
orders,
interim orders.
Ah.
Where are they?
page 15, bottom,
Volume?
volume 1. In my written submission itself.
All right.
I've quoted it. And I've given the name of the convenience compilation for the original. We have considered the matter including amendments to the statutes brought in by the Finance Act 2016 and 2017. We have closely examined the stand taken by the respective parties and what has been stated by the Election Commission in its affidavit, details of which have been set out. All that we would like to state for the present is that the rival contentions give rise to weighty issues which have a tremendous bearing on the sanctity of the electoral process in the country. Such weighty issues would require an in-depth hearing which cannot be concluded and the issues answered within the limited time that is available before the process of funding through electoral bonds comes to a closure as per the schedule noted earlier. In the above perspective, according to us, the just and proper interim direction would be to require all political parties who have received donations through electoral bonds to submit to the Election Commission in a sealed cover detailed particulars of the donors against each bond, the amount of each bond and the full particulars of the credit received against each bond, namely the particulars of the bank accounts to which the amount has been credited and the date of each such credit. Pausing here, my lord, I pointed out that the political party can well turn around and say we don't even know. I'm saying that, and ultimately, my
So the
lord,
purchaser of the bond
Yes.
may not be the person who is actually handing it over to the
Correct.
political party.
that's right. That's why they may say that we don't know. And they can also say that it was not even handed over in person. It was just left at our doorstep. So, or couriered to us. Anything they can say.
The election commission is appearing before us.
Yes, yes. I'll just read out,
Who is appearing for the election commission? Mr. Sharma, you have details of this data which has been submitted pursuant to the interim order.
Order. We have that seal cover. Got that. If my lords,
Do keep it with you in the court so
Yeah.
that at an appropriate time we'd like to look at it.
but this is pertaining to 2019, my lords. That interim order was passed in 2019. So pertaining to that, the data is with us.
But
But
they should
this-
give the data. This was a continuing interim.
But this is not only confined to the 2019 election.
Lords,
The mandate is that you must continue to maintain this data.
as far as the date of 2019 is concerned, lords, that's there in the seal cover. Because if my lords requires
So,
data
Mr.
of,
Sharma, let's be very clear. This order, this is an interim order.
that's right.
It will continue till the decision. So,
There are 40 legal lordships can be. Possibly that's the.
There are?
Para 14 of them.
for the past, that's for the past.
The above details will be furnished forthwith in respect of electoral bonds received by a political party till date. The detail of such other bonds received by such political party up to the date fixed for issuing such bond as per note of the Ministry of Finance dated so and so will be submitted on or before 30th May 2019.
So just one thing now. You're reading paragraph 13 as restricted by paragraph 14? And you have not carried forward the data with regard to post the interim order.
I'll have to seek instructions.
Please take instructions on that.
We'll do that. We'll do that.
14 does not restrict paragraph 13. Paragraph 14 is for the past. Paragraph 13 is from that period onwards.
Because I'll take instructions.
What paragraph 14 says is that in respect of the past period, the data will be submitted forthwith. But para 13 is a continuing direction. This is not only confined to the 2019 election.
Because then I'll seek instruction because I'll be.
Then, my lord, the next order at para 20, which I have quoted, is that mix and match thing. I said this honorable court in its interim order dated 26/3, subsequent interim order, however, based on the government's claims while rejecting the petitioner's prayer for interim stay, had noted the financial statements of companies registered under the Companies Act, which are filed with the Registrar of Companies, are accessible online on the website of the ministry for anyone. They can also be obtained in physical form from the Registrar of Companies upon payment of prescribed fee. Since the scheme mandates political parties to file audited accounts of statements, and also the Companies Act requires financial statements of registered companies to be filed with the Registrar of Companies, the purchase as well as encashment of bonds happening only through banking channels is always reflected in documents that eventually come to the public domain. All that is required is a little more effort to cull out such information from both sides, purchaser of bond and political party, and do some match the following. Therefore, it is not as though the operation of the scheme are behind iron curtains incapable of being pierced. Pausing here, my lord. This is not correct because you can't, citizen can't do this match the following, etc. Because the company does not disclose who they have given the bond to. Company only discloses the total bonds purchased. The political parties only discloses the total bonds received. So you can't, no citizen can match. Only the government, only the state bank, only the state bank. State bank and any law enforcement agency which asks such information from the state bank. Strictly speaking, only that. Otherwise, citizens certainly can't. It completely defeats the citizens' rights. Now, my lord, I just want to read out the objections of the Election Commission. Para 25. When this bond scheme was introduced, the Election Commission as well as the Reserve Bank strongly objected to it. Election Commission, para 25. In its letter, and we have given the pages of the primary documents from volume 4 of the compilation. I am in the interest of conserving time, I am just reading these relevant parts. अच्छा चलिए. Volume 4, then your lordship may turn to the Election Commissions, page 467. This is an important communication by the Election Commission.
Volume 4, page 5.
467 of volume 4. That's document number 37, document number 37.
Page
44.
In the Finance Act 2017. Sir, I am directed to draw your attention to Finance Act 2017, which has introduced certain amendments to the Income Tax Act, Representation of People Act, Companies Act, and will have serious impact on transparency aspect of political finance funding of political parties. And then they mention the amendments, etc. And then they say, Acha. 2.2. It is evident from the amendment that has been made that any donation received by a political party through an electoral bond has been taken out of the ambit of reporting under the contribution report prescribed under Section 29C of the RP Act, and therefore this is a retrograde step as far as transparency of donations is concerned, and the proviso needs to be withdrawn. Moreover, in a situation where contributions received through electoral bonds are not reported on perusal of the contribution reports of political parties, it cannot be ascertained whether the political party has taken any donation in violation of the provisions of 29B of the RP Act, which prohibits political parties from taking donations from government, companies, and foreign sources. Income Tax Act. An amendment has been made to Section 13A of the Income Tax Act, whereby no donation exceeds 2,000 rupees can be received by a political party other than by account, pay, check, etc. However, the limit for anonymous donations by a political party still remains at 20,000 in Section 29C of the RP Act. The RP Act needs to be amended to reduce the limit of anonymous cash donations to 20,000 so as to bring these two acts in consonance to each other. Pausing here, my lord, it makes no difference in my respectful submission, because the political party earlier said that we have received X crores from 20,000 or less. Now they'll say we have received the same X crores from 2,000 or less. If they don't want to disclose those cash donations, they don't have to. So it's not going to make any substantial difference whether the limit is 20,000 or 2,000. Then, my lord, Companies Act. Certain amendments have been proposed to Section 182 of the Companies Act, where the first proviso has been omitted, and consequently the limit of 7.5% of the average net profits in the preceding 3 financial years on contributions by companies has been removed from the statute. This opens up the possibility of shell companies being set up for the sole purpose of making donations to political parties with no other business of consequence having disbursable profits. So the Election Commission had pointed this out, that look, you are doing this, but this will open up the gates to shell companies being used to donate money to political parties. The second amendment in 182(3) abolishes the provision that firms must declare their political contributions in their profit and loss account, as this requirement is now reduced to only showing the total amount under this head, which would again compromise transparency. In view of the position explained above, I am directed to state that the amendments made in RP Act, Companies Act, introduced by the Finance Act, referred to in para so and so, may be reconsidered so as to provide a transparent reporting of contributions received by political parties through electoral bonds. And a provision should be made in the Companies Act to declare party-wise contributions made by companies in the profit and loss account, so that transparency in the fundraising by political parties is maintained. With respect to para 4.1, the Commission has expressed its apprehension that the abolition of relevant provision of 182 would lead to increase I was just reading the last paragraph of that EC's letter, para 6 at page 469. Yes, Lord, I was just reading the last part of that EC's letter. The last part is at page 469. Last paragraph, para 6. With respect to para 4.1, the Commission has expressed its apprehension that the abolition of the relevant provision of section 182 would lead to increased use of black money for political funding through shell companies. As I said, my lord, what could be happening is that, let's say, I mean, one of the allegations in that Adani matter is that the money which was siphoned out by over invoicing to companies which are registered in tax havens were thereafter funneled into these companies. Now, suppose, my lord, that money is now funneled through a subsidiary to political parties. That's really black money. It's really black money and in a way foreign money, which is coming to political parties through these shell companies which have been set up as subsidiaries.
Now, Mr. Bhushan,
in
could we go straight to your formulation now?
Yes, yes.
I think we've
Just-
seen the
just one-
scheme, we've seen the
One
RBI,
RTI reply.
RBI reply perhaps to make sure, so that they now can formulate, so then we can go to Mr. Sabri.
Now, just, my lord, just the RBI letter and the government's reply under, on this. They
Show us
said,
that. Yeah,
no,
just take
government
us to-
said, not RTI. Government in parliament said,
Let us see that.
yes, page 489,
Volume 4.
volume 4, page 489. They were asked whether you have received any concern from the election commission, and they said no. Page 489. Will the Minister of Finance please be pleased to state, question D, whether it is a fact that the Election Commission has raised concerns on the issue of electoral bonds? If so, details as well as reasons thereof. Now see the answer to question D at page 490. The government has not received any concerns from the Election Commission on the issue of electoral bonds. I mean, they treat this so casually. You can just say whatever you want and get away with it. And the RBI's objection is at page 437.
Which is that government has not received it.
.437 of the same volume. Document number 29.
No, foreign funding, probably. This is mainly on account of foreign funding or otherwise?
No, this is 30th January 2017, letter by the RBI,
What page is that, Mr.
page
Bhushan?
437 of volume 4. Document 37.